Students, under Family Law 2, we have been studying not only Mohammedan law, besides Mohammedan law, we have been required to study Indian Succession Act and Family Courts Act and etc. and etc. Here, why I am telling, I am stressing this aspect that here normally the students, they felt uneasy with regard to the subject Mohammedan law. It might be for different reasons. One of the reason is that they may get the question, they may get the common question, they may get some question with regard to the different topics. For example, under Mohammedan law also, there will be a question with regard to the concept of will. There the question may be with regard to the define will under Mohammedan law, state the limits of testamentary powers of the Mohammedan. So likewise, there will also be a question with regard to the will under Indian Succession Act. There the question will be like this: define will, what are the kinds of will, how the unprivileged will be executed. So in this way, the question will be like this. And there will be a question may also come in this way in the previous question papers, that is define privileged will, state the rules for the execution of the privileged will. So in our previous video, we have seen with regard to the concept of the will under Mohammedan law. Today, let us concentrate with regard to the will under Indian Succession Act. So among these two things, that is one is under Mohammedan law and another is under Indian Succession Act, there will be a definite question will come on the concept of the will. So today let us see what has been said under Indian Succession Act with regard to the concept of will. So with regard to the execution and modes of the will under Indian Succession Act, under chapter 2, we can see the details. But under chapter 1, we can see the definition of a will. So here, what are all the things we have to see with regard to the concept of a will is that here, who can make a will, who can execute the will, and the kinds of wills, and how the will could be executed, and with regard to the revocation of the will. So here our primary concentration with regard to the concept of the privileged will and the unprivileged will. So normally under the Karnataka State Law University, there will be a question with regard to the concept of will, that is primarily either it is with regard to the privileged will or unprivileged will. So we have to, first of all, we have to see the definition of the will under the Indian Succession Act, and we have to discuss some characteristics of the will, and we have to discuss with regard to the primarily there will be privileged will and the unprivileged will and execution aspect. So these aspects we have to see, and there are certain other kinds of will are there other than this privileged will and the non-privileged will. There are other the different kinds of wills are there, but they don't find much of the place in the Indian Succession Act. Here in the Indian Succession Act, the privileged will and non-privileged will has got the primary importance. Here we can get the other kinds of will, that is non-cupative or oral will, or holograph will, or inefficacious will, or mutual wills, or joint wills, and contingent and conditional will, and duplicate wills. That means these are all the different kinds of wills. That is, other than the privileged and non-privileged will, we can find these the other kinds of the will. So let us see what has been said with regard to the privileged will and the unprivileged will with regard to the execution, and with regard to the nature of the privileged will and the unprivileged will. So under Indian Succession Act chapter 1, under section 2H of the act, the will has been defined like this. That is, the legal declaration of the intention of a testator with respect to his property, which he desires to be carried into effect after his death. That is, here it has been given that will is nothing but the legal declaration of the intention of a testator with respect to his property, which he desires to be carried into effect after his death. That means, here what are all the things we can see? There should be a testator, that means who writes the testimony. That is the first thing. And he has said with regard to the devolution of property. That means how the property should be devolved. So that is the second important thing. And next is the intention of a testator with regard to the devolution of the property. It may be after his death or her death, because in law he includes she. So even normally it may be said in the gender he only, but includes she also. That is the second aspect, that is intention of the testator with regard to devolution of the property. Next, there should be the legal declaration. That means intention should be of a legal declaration. And it is needless to say that there should be that legal declaration should be in existence with regard to the some property. And here the primary thing is that that effect of this will should come after the death of the testator. So these things we can come across under this definition of section 2H of the Indian Succession Act. So the definition has been given in the Halsbury, the dictionary also. Here, a will is defined as the declaration in a prescribed manner of the intention of the person making it with regard to matters which he wishes to take effect upon his death. So this has been definition. This is the definition which has given under the Halsbury law of England with regard to the concept of the will. So we have seen what is meant by will under the Indian Succession Act. So with regard to these the wills and codicils, we can see the provisions from section 57 to 62 and 66 to 69 with regard to wills and the codicils. So let us see what we can evince out of this definition. So this can be seen under different the characteristics of the will. So as I have told you, there should be a testator. So and there should be a legal declaration should be there with regard to the devolution of the property. That means there should be a testator should be there who makes the testimony with regard to the devolution of property, and there should be a legal declaration with regard to the with regard to the devolving the property, and it should be followed by the necessary requirements as which has been laid down under the section 63 of the Act. Here what we have to see, what is the the minimum requirements, what are all the conditions for the making of the will, that the testator of he should be of a sound mind. And second one is that testator should not be a minor. So these aspects we can see under section 59 of the Indian Succession Act. So here that is the primary thing under Indian Succession Act. Under this section also, that is section 59, who are all the other categories of persons who can make a valid will. So those things also we can look into it. That means a deaf and dumb person can also make the will, and that is ordinarily insane person who he cannot make the will, but when he is in a in a good condition, when there is no insanity, he can make a will. And a person who under intoxication, he cannot make a will. So here there is a provision with regard to the who can make a will with regard to that means what are the conditions for making a will. So this is the common thing we can see. And here under section 63, the conditions has been said with regard to the valid will. So here first aspect is that there should be a testator, there should be a legal declaration, and the other aspect is the declaration should be relating to the property. There should be the existence of the property. Here the testator which he wants to dispose of, he wants to devolution of his property. So if the declaration contains no reference to the disposal of the property, but merely appoints a manager to manage the property, then it's not a will. Here the intention of the legal declaration of the testator should be of a clarified document. So if it is with regard to the appointment of some person to manage the property, then it will not become a will. So that aspect we have to see. And thirdly, it is with regard to the declaration. It is with regard to the disposal of the property. So disposal of the property of the testator, which is intended to devolve after the death of the testator. So this aspect we have to see. That means there should be an intention should be there. So there should be intention should be there, and there should be the existence of the property should also be there. So these are the characteristics of a will. And here the other characteristics is that there should be the will should be the will which has to be come after the death of the person. And the other requirement is that here there has also been provision has been made with regard to the revocation of the will. That means during the lifetime of the testator, he can revoke the will. That means he can make changes, he can make the will afresh. So these are the essential characteristics of a will. So let us go with regard to the what is privileged will, what is unprivileged will. So where privileged will can be made. So what are all the how this privileged will can be executed. So in your exams, normally there will be question with regard to the privileged will and the unprivileged will. So there will be the question may be asked with regard to the what is the privileged will and what is the unprivileged will and how it can be executed. Here with regard to the privileged will, the name itself it is like a privileged. So that means the certain categories of persons they have got the privilege with regard to making the privileged will. Certain categories of persons they have got the privilege to make the will because of their special they are special criteria of people. because of the special criteria of the people, certain categories of persons, they can make a privileged will. The rest of the persons, they make the will and they can be called as they can make the unprivileged will. So let us see who are these the privileged people. So the privileged people under the concept of the privilege will, which has been given with regard to the criteria of people. So which are the persons who can come under this concept of privilege will, who can make the privilege will, is that a soldier, an airman and a mariner. So these three persons, these three categories of criteria of people, they can make the privileged will. And what is the conditions? When these persons, they can make this privileged will, means they can make this privileged will when they are in expedition, when they are engaged in the actual warfare, or when they fear with regard to the apprehension of death during warfare. So under those exigencies, if a soldier or a airman or a mariner, because of their special conditions of the working atmosphere, if they make a will, then that will can be called as the privileged will. So these criteria of people, they can make the will. So this aspect we have to see. And let us go with regard to this concept of the privileged will. Here, how the privileged will can be executed. So what is the mode of execution of the privileged will? So here, with regard to the execution of the will, there are certain basic rules are there. With regard to the privileged will also, some basic rules are there. Unprivileged will also, so there are certain basic rules are there. So with regard to the concept of privileged will, we have seen what is meant by privileged will, who can make the privileged will, we have seen. Let us see who can make the unprivileged will. So which category of persons who can make the unprivileged will? So here the persons other than the soldiers, airmen and marine, other than the persons who are other than the persons other than the soldiers, airmen and mariner, any layman or any general person can make a unprivileged will. So this is the difference between the privileged will and the unprivileged will. That means here with regard to the privileged will, under section 65, we can find the provisions with regard to the who can make the privileged will. Under section 63, we can find the who can make the unprivileged will. So this aspect we can see under section 63. So here under section 63, we can find the kinds of the will also. That is, so here under section 63, we can see the unprivileged will. With regard to the section 65 and section 66, we can see with regard to the privileged will. So we have already seen who can make the privileged will and when he can make the privileged will. Let us see how this privileged will can be executed, the execution of the privileged will. So there are 6 the rules are there with regard to the execution of the privileged will. The first one is with regard to the privileged will, the testator may write such a will only in his own handwriting. In such a case, it need not be signed by him or attested by witnesses. So with regard to the execution of the privileged will, we can see that is how this the privileged will can be executed is that the testator, that means the author of the will, the person who does the testimony, he he may write the will. It may be in full in handwriting, or in such when he writes the privileged will in his own handwriting, there is no requirement of his signature, or there is no necessary of the attesting witnesses. So that's why it can be called as the privileged will. So if a person, that is the special criteria of people, it is soldier, airman or marine person, when they engaged in actual warfare or an expedition, if they write in their own handwriting because of their special conditions, if they write the things in their own handwriting, then there is no necessity of the attesting witnesses. And the other aspects what we have to see, there is no requirement of signature also, because what happens if the person is in warfare, these complete formalities cannot be done. So in exigencies, we cannot expect him to get the witnesses. We have to that is there may not be time to write the even that will in full also. So during warfare, how the situation is there, you can come across. There he may not be able to sign the document also. So certain times the document may not be written in full also. Certain times he may tell orally also. He may tell orally to some person to write the will. Or certain times he may write the will off, and some other he may ask some other person to fill the rest of the will. So these are all the conditions. This has been accepted under the execution of the privileged will. So the second aspect is the will may be written wholly or in part by another person and signed by the testator. In such cases, attestation by witnesses is to be necessary. That means here the will may be written wholly or in part by another person and signed by the testator. That means here the will may be written completely by the testator, or certain times he may not be able to write he is able to write the will in full. That at the time it may be written by some other person, and it should be signed by the testator. And in such cases, there is a requirement of the attestation. And third aspect is, even if the will written wholly or in part by another person, but it is not signed by the testator, it is valid. So if the will is written fully or in part by another person, this is not the testator. Here, why in the earlier condition it has been said that here some part the testator will write, but some other part the other person will write. So there is a requirement of the attestation. But with regard to the third aspect, if the will is written wholly or in part by another person, but it is not signed by the testator, it is valid, provided it was written under the testator's directions, or if he recognizes it as his will. So what happens here, under the third condition, the will can be written in full or in part by another person, but it should be signed by the testator. But it can be valid if it is done under the under the complete guidance of the testator. The next aspect is if the soldier, airman or mariner had given the written instructions to prepare his will, but died before it could be prepared. So as you know, how the wars will be going on, how the exigency will be there, how the person is going to suffer out of the wounds which he got caused by the during the warfare. So at the time, the person who comes under this special category or criteria of the privileged will, he given complete direction to the some person to prepare will. But before completion of that will only, if the person dies or the testator dies, then whether what is the validity of that will means it will be of valid in nature. So here that is here what we can see is that even that verbal instructions for preparing will could amount to a valid will made by such a person, provided that means there are three conditions are there with regard to the in order to become a valid will on the basis of the verbal instructions. That is, the verbal instructions were given in the presence of two witnesses. That is the first basic thing should be there. That is, there should be two witnesses should be there while giving his instruction. And second is, such instructions have been reduced in writing in his lifetime. During his lifetime only, the instructions was getting reduced in writing. And last one is, he has died before the formal will could be prepared and executed. So before it becomes a formal will, he succumbed to death. So these are the three things we can see with regard to the verbal instructions. So lastly, what we can see here with regard to the privileged will, a will can be made by a soldier, airman or mariner by oral declaration of his intentions before two witnesses present at the same time. However, what we have to see that here, however, such an oral will automatically becomes null and void at the expiry of 1 month after such a person being still alive has ceased to be entitled to make a privileged will. That means the primary condition is that here this privileged will become inactive after a period of 1 month if the person who makes the privileged will, he gets survived. That means he is in existence. He has not been succumbed to death. So he can make at such instances he can make the unprivileged will on par with the other persons. So this is the aspect we have to see with regard to the privileged will. So we have seen what is meant by will under section 2H, and we have seen the characteristics of the will, and we have seen what is meant by privileged will, and how this execution of the privileged will can be done, and we have also seen what is meant by unprivileged will also, and let us see how this the execution can be done with regard to the unprivileged will. Here there are certain few rules are there with regard to the execution of the unprivileged will. So the first aspect is that with regard to signature, second one is intention, third one is attestation. So these three things we have to see with regard to the execution of the unprivileged will. Here with regard to signature, either the testator must sign or affix his mark to the will, or the will must be signed by some other person in the testator presence under his direction. This is the basic thing we can see with regard to the execution of the unprivileged will. That means a testator, he may put his signature or he may put his thumb mark. So yeah, he can make his signature or his thumb mark, that is affix his mark, or the will must be signed by some other person in the testator presence under his direction. That means here the aspect with regard to the unprivileged will, that the testator certain times he need not sign the will. So on behalf of the testator, some other person may also sign this document, that is the will. So that is the thing we can see with regard to the unprivileged will. The second aspect is what we can see with regard to the intention behind the signature. Here, such signature or mark must be so placed that it appears that it was intended to give effect to the writing as a will. That means, here why such signature or mark must be placed that appears that it was intended to give effect to the writing as a will means, here certain times what happens, there may be what we call certain gaps may be there under a will. While writing a will, there may be certain gaps with regard to the while writing the will, there may be some gaps between the passages. So in order to fill that fill that passages, that means in order to clarify the ambiguity, in order to clarify that dilemma, there should be some signature should be placed. So there should be the clear intention should be there when there is a place or space has been left out in while doing the preparation of a will. So there should not be any ambiguity. There should not be any dilemma after the death of the testator with regard to the execution of the will. So there should be clear intention we should have to get. So that is the second thing. And third one is there should be the attestation is also very much. Here the attestation will the will must be attested by at least 2 witnesses as under. That means it may be more than 2, but at least there should be 2 witnesses should be there. And what is the primary thing is that this each witness must have seen the testator who is signing the document, and this aspect in the presence and the dictator. So suppose if he has not signed, so the other witnesses should see that the testator who is giving the directions for preparation of the will. So the last one is aspect here with regard to the execution of unprivileged will is that each witness must have received from the testator a personal acknowledgement of his signature or of the signatures of such other person. And the last aspect is each witness must sign the will in the presence of the testator. That is, each witness has to sign the will in the presence of the testator only. That means who is the testator? Who gives his testimony with regard to devolution of the property by way of will, although they need not be signed in the presence of each other. So here the condition is that the testator should see it. The testator should see it. So here the witnesses they need not have to see each other. That means the witnesses may not see each other with regard to the signing the document. So that is the aspect we can see with regard to the execution of the unprivileged will. So we have seen who can make the unprivileged will. That is other than the soldier, airman, mariner, any layman, any general person can make the unprivileged will. So, and we have seen what is the basic rules with regard to this unprivileged will, that is with regard to the execution of the will. So this is very much important from the examination point of view with regard to the privileged will or the unprivileged will. And there are other kinds of the will are also there. That is non-cupative or oral will. That means an oral will is also valid. Here an oral will is one which has been declared by the person, making it in the presence of the witnesses. That means here the other kinds of the will is that an oral will is one which has been declared by the person, making it in the presence of the witness. So this is also a other kind of the will. Next one is holograph will. So holograph will is that this sort of the will can be written by the testator in his own hand. This can be called as the holograph will. And next one is officious will. Here in officious will, a will which is not in keeping with the testator's natural affection, moral duty, as where testator bequeath all his property to a stranger to the complete exclusion of his wife, his children and other relatives. Such a will is perfectly legally valid. So in officious will, what is the specialty of the officious will means? Normally what we can see, this will can be done on the basis of the natural love and affection. But here in officious will, will can be done in favor of some stranger. excluding their wife and children. That means his wife and children. Because as you know that now the trend is that now the humanity is losing that when a person becomes old and the children, his children or her children might not see the welfare of the parents. They will not take care with regard to the parents. So they will here now that trend is there. Now when the parents become old, it is the normal trend that the children, they will not take care with their parents. They will forget how the care and how the interest has been taken by their parents when they are young. So that's why in order to exclude such children, a person can make a will, may devolve his property even to a stranger. So that aspect we can see under the inefficacious will. And next one is mutual wills. Here, how these mutual wills can be done is, here, this aspect we can see that two persons are said to make mutual wills when they confer. That is, when they confer with regard to the reciprocal benefits upon each other under their will. So this aspect can be done with regard to the mutual wills. And next is joint will. Here, with regard to the joint will, it has been said that a joint will is defined as a will made by two testators contained in a single document. That means normally husband and wife, they will make this sort of the joint will, and that duly executed by each testator contained in a single document. That will be called as a joint will. And next one is contingent will. So that contingent will is that conditional will. Upon some condition, on happening of certain event or condition, the will has no effect. So on attaining such condition, the will get the effect. Last one is duplicate will. So here the will can be prepared in duplicate. One may be kept in the locker under the in the bank under the locker, and the other may be kept with the testator. If one if the will under the custody of the testator is lost, then there is no the validity of this duplicate will be suspected. So these are all the kinds of the wills we have seen. So this is very much important from the examination point of view with regard to the privileged will and the unprivileged will, and with regard to the execution of the wills. So these aspects you have to carefully, you have to make the notes with regard to this privileged will and the unprivileged will. This is very much important from the examination point of view.